application in the matter of the Federal Republic of Nigeria and Zhongsan Fucheng Industrial Investment.
Yes, Mr. Hussain.
Can I just check that you have with you a application bundle, which is for today, what's called an appeal bundle, which is a bundle before Lord Justice Mails, and then 2 authorities bundles?
Yes, I think so is the answer.
Excellent.
I'm not sure whether...
Well, no, I'm not sure I do. I have something called a hearing bundle.
Yes.
If I can just get this off my chest,
Might be on my
I got these little A5 ones, and since I wasn't available yesterday, I've had to work on those. These only came in yesterday, the proper bundles, so I don't know what happened about all that. But anyway, so you may find me rather running from one to the other.
Yeah.
So the herring bundle is a bundle for today, for the application, and then you should have variously called an appeal bundle or a core bundle, which is the application, which is the bundle before Lord Justice Mails.
Yes.
And then there are 2 authorities bundles.
Yes.
Excellent. My lords, this is an application under CPR Rule 52.
Well, can you, before you go any further, it seems to us, subject to your persuading us to the contrary, that the 5230 application, ultimately, whether it's has any merit, as it were, academically, it would turn ultimately on whether or not we think there's anything in the permission to appeal. So it seems to us that you should focus your submissions on permission to appeal and why you say you should have permission to appeal. Because if you lose on that, then the 5230 point doesn't really arise. So I think, and this is certainly the approach I've adopted in similar cases where we've had hearings, rather than we know all about what 5230 threshold is, etc., etc. But if you don't get as far as permission to appeal, then you don't get as far as 5230. Likewise, if you get to permission to appeal, then 5230 is easier. So just focus on the permission to appeal more than perhaps the detail of the 5230, please.
I'm grateful, my lord. I will, in that case, make my submission in 4 parts. I shall first look at the law on Section 1 of the State Immunity Act 1978, referred to in the permission to appeal application. I will then look at the key material facts emphasised in the PTA application, and then I will go through the grounds of appeal. If I can start with the key propositions of law, the Act is at the Supplemental Authorities Bundle, tab 1, page 3.
And this is going to supplementary authorities bundle. I haven't got that.
No, I've got something that says on the back supplementary authorities bundle, but turns out when I look inside it to be yet another copy of the application bundle.
Yeah, I mean the bundles here were I don't want to complain too bitterly, but they were literally ridiculous. I mean, A5 bundles are, I'm afraid, no use at all, especially if you've got rather poor eyesight, as I have at the moment. Later, in 3 weeks' time, when I've had my cataracts, then I'll be able to read even smaller than A5. But I mean, it's just not good enough, I'm afraid. So my clerk had to literally print out everything that we had. What I've got is 2 authorities bundles, which has got a whole load of cases in them, which I think you were before. I'm not sure where they came from. Oh, they don't even seem to contain the Act, frankly.
Well, my clerk has worked it out. What I've got marked hearing bundle, she's put a post-it on the back saying supplementary bundle, which I think means supplementary authorities bundle. So I have now found it, but may I endorse what my lord has said? It's just not good enough.
I do apologise.
I mean, there's huge resources here. The most important thing is to get the bundles right, and you can't even do that.
I apologise.
Somebody's going to have to give me a copy of the supplementary authorities bundle.
Of course, my lord. I've got a clean copy here, but unfortunately it's in A5.
Well, I'll cope with it as best I can.
My lord, it appears my solicitors may have an A4 version unmarked for my lord.
I'm grateful to Mr. Harris.
Okay, that's good. Thank you very much. Yes.
My lord, just so that you're not confused, we had to break the PDF as was sent to us. We had to break it into 2 files to print it. So it's in 2 files. So when my learned friend refers to tabs, I think the first 10 tabs are in volume 1 and the second from 11 to 23 are in volume 2.
Okay, thank you very much. So where do we find the Act?
It's in tab 1 of that file, sir. My lord, sorry.
Tab 1. Yep, okay, got that.
So if we start with section 1.1, general immunity from jurisdiction. A state is immune from the jurisdiction of the courts of the United Kingdom, except as provided in the following provisions of this part of this Act. A court shall give effect to the immunity conferred by this section, even though the state does not appear in the proceedings in question. A key point in Nigeria's grounds 1 and 2 is that section 1.2 requires a court must determine the existence of an exception to state immunity before making a judgment on the substantive claim, regardless of whether the state appears. And Nigeria's position is that the judge's conclusion that her obligation to make such a determination only arises if the state makes a timely appearance is unsustainable on the wording and meaning of section 1.2. Staying within the Act, if we then
Well,
go...
the implication of that is that on every single ex parte application to enforce an arbitration award against the state, there has to be a full-blown hearing where the matter is determined on a balance of probabilities, even though the state, in the end, doesn't actually raise state immunity. I can't imagine a more wasteful use of the resources of the commercial court than that, frankly.
Yes,
the
but that
practice
is
which
not
has
the-
been adopted here, as in so many other cases, is there's an ex parte application to enforce, and on that, the claimants drew the attention of the court to the state immunity point and addressed it and said why the state immunity, they submitted the state immunity point didn't arise. The judge decided that on a prima facie basis and then on the basis that your clients would have the opportunity to come in if they wanted to and raise the issue of state immunity and have a full argument. And at that stage, if there had been a hearing, if you'd acted in time, then there would have been a hearing at which the judge would have decided on a balance of probabilities. But the practice of the commercial court is to deal with these matters ex parte, usually on the papers, not to have unnecessary hearings. So you'll need to persuade us that the judge got that bit wrong, frankly.
I'm obliged, my lord. Firstly, it's not Nigeria's proposition that in every case a full-blown hearing must be held. It is a matter for the judge what kind of hearing, if indeed any hearing they need, to determine on the balance of probabilities whether an exception under the Act applies. So that is not something we're suggesting. But the point is that there must be a determination to the civil standard in every case, because the claimant, the non-state party, will of course aver an exception to state immunity if it is suing a state. And the question then becomes a live one. And we say that section 1.2 clearly means that the judge has an obligation to decide that point, regardless of whether the state appears. And what the judge in this case said was, well, the standard of proof may vary depending on whether or not the state appears, moving from a prima facie case to balance of probabilities. And we say that is wrong. The Act does not allow that. But also, as I will show you...
Is that right? A prima facie case is a balance of probabilities unless the contrary is shown. What's the distinction you're advancing?
Well, prima facie case is not, my lord.
Why not?
I'll have to differ from that because that requires a look at the facts. So for instance, in this case, we look at the application. The point was made that there was a live issue throughout the arbitration as to whether the dispute was one that the parties had agreed to refer to arbitration. In particular, there was a dispute, for example, whether the investment was validly made under the contract, under the laws of the state, Nigeria. There was a dispute as to the fork in the road provision, a very lively dispute. And it was not suggested that these are matters that can be decided prima facie. But prima facie, my understanding is and the way the judge looked at it, was that she had not inquired into the facts of the law. She had just understood that there was prima facie an arbitration agreement that could cover the dispute. I don't think it was suggested that there was any investigation that should occur at the time of the ex parte.
But your clients
application.
made it, your clients following the arbitration award, where the arbitrators obviously determined their jurisdiction under Section 30 of the Act. Your clients then made an application under Section 67 to challenge the jurisdiction, which they abandoned.
Yes.
If they hadn't abandoned it, that issue would have been determined at a Section 67 hearing.
Yes, but
The
it
judge
was...
had that in mind as well, and she was entitled to have that in mind.
But that is not an exception under the Act. my
But
lord.
it's an indication that the arbitrators may very well have been right, that they had jurisdiction.
My lord, with respect, that simply cannot be part of a determination on
Well,
the
is
balance
your
of
client-
probabilities.
What I don't understand in all of this, because you're quite coy. I mean, I follow the point that you say that these disputes were not, as it were, within the arbitration agreement, therefore the arbitrators had no jurisdiction. But have you got some other freestanding ground for saying that Section 9, there wasn't a Section 9 exception?
Well, there were a number
Play
of
here.
grounds which were aired in the ex parte application itself, one of which was that there was a fork in the road clause in the investment treaty.
Sorry, there was a what?
A fork in the road clause in the investment treaty, whereby if you went to court, you couldn't arbitrate. And that had been wrongly applied by the tribunal. And these were all live issues that were consistently maintained throughout the arbitration. These were not unknown issues, hence why they were named in the ex parte application. It is important, sir, my lord, that we look at the grounds of appeal, which are based on the law of state immunity, by and large, certainly grounds 1 and 2. There is a subsection of ground 3 that looks at conduct.
Yeah. Okay.
There are two propositions that are central to the grounds of appeal and the application for permission. The first proposition is that absent a determination of an exception to immunity under the Act, the court has no jurisdiction against the state. This is in distinction to a position where the court withholds exercise of a jurisdiction it does otherwise have. And these cases are in the application skeleton. If we go to the hearing bundle, tab 6.
So sorry, where are we going?
We're going, my lord, to the hearing bundle, tab 6.
Yeah.
And we're going within, you'll see there the skeleton, and then I'm looking at page 27 of the bundle, page 13 of the skeleton, so paragraph 28 through 31. I'll invite you to consider those, my lord, because they are central to the grounds of appeal, both 1 and 2. But if I can go to the quote at paragraph 31, in Ben Carbush and the Embassy of Sudan. The quote is from paragraph 19 of the judgment of Lord Sumption. It says, proceedings brought against a state entitled to immunity are not a nullity, but the court's jurisdiction to entertain the proceedings is limited to examining the basis on which immunity is asserted and determining whether it applies.
No, we're just pausing there. Applying that principle, that would, it seems to me at least, that would include whatever procedural rules the court applies to that issue of determination. And what would be said against you, I think, is that here, the court, the way in which this works is that the court gives, makes an order ex parte, but then gives to the state an extended period of time to make an application under the State Immunity Act. And that includes the entitlements to say, if you're out of time in making that it's too late. Otherwise, this becomes a recipe for anarchy, frankly.
My lord, I think if I'm
Because
allowed,
you can just ignore the court's order giving you 2 months and 2 weeks, come along 3 years later and say, we're entitled to restate immunity. So, I mean, I follow the point, the court doesn't have jurisdiction, as it were, substantive jurisdiction. But at the moment, I'm struggling with the concept the court doesn't have any procedural jurisdiction to, as it were, to govern how it deals with the application that Lord Sumption's referring to.
Well, so, my lord, I haven't gone through the point by Lord Sumption, but it's important not to jump ahead of the argument. I'm not suggesting the court doesn't have procedural jurisdiction in terms of setting out the procedure for the determination. The point is the court must make a determination, which it has not done. And absent that determination, it has no jurisdiction. That is the point. If I can continue, and I'll come back to this point, I am sensing that we are perhaps moving away from the ground of appeal to questions of conduct. And I would urge this court to perhaps focus on the law for now.
Which is it that your grounds of appeal include a ground that effectively says that the court cannot apply the sanctions regime under Dent and White. Therefore, the court doesn't have the procedural powers which it would otherwise have.
That is not what it says, my lord. It says that jurisdiction only arises if there is an exception to immunity under the Act. It cannot arise by way of sanction. So, and it's really important because I was not allowed to, there is no immunity, there's no exception to immunity that a state has by way of sanction. The exceptions are the ones enumerated in the Act. And the exception must be determined, which has not been done yet. And there is a difference, my lord, between the court being allowed to organise a procedure of the determination, which we say yes it can, and the fact that the court says, well, because you haven't followed the procedure, I don't need to make a determination.
But what happens if the court sets a procedure substantively to the same effect as this one, but saying explicitly the parties must attend on such and such a date to determine the question of, so that the court can determine the question of jurisdiction, and you simply don't turn up, you say that there has to be a hearing nevertheless, or at any rate a decision which says, because I haven't heard any argument to the contrary, I determine that there is no state immunity. Is that what you're saying? Is that the problem here, that the judge hasn't made a finding about state immunity? So it's purely, there'd been a single sentence saying,
well, it has to be a bona fide determination, so the judge would then apply his or her mind to the facts that are presented by one side.
But if no facts had been presented by the other side, it would be pretty straightforward, wouldn't it?
Well, in that case, the judge may look at the papers and say there's nothing here. But in this case, and that is precisely what happened.
Well, that's what
in
my
the
lord's
Mauritius
putting to you,
case.
Mr. Hussain, I think.
Sorry, my lord?
I think that's the point that my lord's putting to you. That
Well, that's not what happened in this case.
The judge said, you're too late, you're out of time. You can't, it's too late to come along now and say, we want yet more time to consider making an application.
Well, I think we're talking at cross purposes. If I can just answer his lordship's question first. In the Mauritius case, that's exactly what happened. The embassy was invited to make representations of state immunity. It didn't make them. The court made a determination on the papers it had. In this case, the ex parte application itself says that there may be defences on the grounds of state immunity. These are the ones that we've seen from the arbitration. The judge, of course, if the other side did not appear, will then make a determination on the papers in front of her.
What is the substantive difference between having made an ex parte order, which by definition means that the judge has formed the view that there is no state immunity, otherwise she wouldn't have made the order, and giving her a liberty to set aside?
Well, I don't agree with you, my lord, that is what the judge found. And that is the whole basis of the whole line of cases, which your lordships don't appear to have read, which say...
Now, don't need to be rude, Mr. Hussain. We have actually read the cases.
Right, the cases say in terms that a properly arguable case is not good enough. You must decide on the balance of probabilities.
So that's in cases where the state has come before the court. All those cases are cases which are inter partes. We're talking about what happened ex parte.
Well, firstly, that distinction doesn't itself create any point of principle. They're not all cases. For example, in Mauritius, the state didn't appear for the state immunity hearing. But as a matter of principle, if I'm allowed to proceed with the first point, if there is no jurisdiction, then the jurisdiction either exists or it doesn't. Absent an exception to state immunity, there is no jurisdiction. The court can't deem a jurisdiction it doesn't have. If I can just stay with you.
I'm sorry, Mr. Hussain, but I'm not following what it is you say the court didn't have jurisdiction to do.
Yes, if I'm permitted to actually read out the quotes, you might have some assistance in following me.
Well, you're still being rude, but there we are.
I apologise if I'm being rude.
Yeah, well, you are. Just be careful.
I will be. If we go to the quote from the skeleton of paragraph 31.
Yeah.
Per Lord Sumption, proceedings brought against the state entitled to immunity are not a nullity, but the court's jurisdiction to entertain the proceedings is limited to examining the basis on which immunity is asserted and determining whether it applies. As International Court of Justice put it in jurisdictional immunities of the state, Germany and Italy, Greece intervening, the question whether the acts relied upon are such as to attract immunity must be determined before the jurisdiction can be exercised, whereas the legality or illegality of the act is something which can be determined only in the exercise of that jurisdiction. The impleaded state may consent to the proceedings, where, however, it does not consent, there is no jurisdiction to proceed to the judicatory stage. The court must dismiss the claim. As Lord Bingham observed in Jones and Saudi Arabia, Article 6 cannot confer on a court a jurisdiction which it does not have, and a state cannot be said to deny access to its courts if it has no access to give. And then we see the quote from Lord Millet in Holland and Lamp and Wolf. And if we look, my lords, at the last two sentences in that quote, state immunity, as I've explained, is a creature of customary international law and derives from the equality of sovereign states. It is not a self-imposed restriction on the jurisdiction of its courts, which the UK has chosen to adopt. It is a limitation imposed from without upon the sovereignty of the UK itself. And that is a key point. The jurisdiction either exists or it doesn't, and it can only exist if an exception to immunity under the Act arises. And that is why we say that procedural burdens, etc., cannot be a means to override or reason to override the need to make a determination. I take your lordship's point, and I do apologise if I appear flippant, that these would be burdensome in some cases, but that is the nature of state immunity, and that is the nature of the obligation both under international law and under the Act. And I want to emphasise, if we go briefly to Jones in Saudi Arabia, which is in the supplemental authorities.
Yeah.
Thank you. So it's in that same file where we have tab 4. And we're looking at the last page of the judgment per Lord Hoffman. Paragraph 101. He says, I'll wait for you to get them up.
Yeah, Lord Hoffman.
This is page 306 of the report, page 121 of the bundle. Paragraph 101. As Lord Millet said in Holland and Lamp and Wolf, state immunity is not a self-imposed restriction on the jurisdiction of its courts, which the United Kingdom has chosen to adopt, and which it can, as a matter of discretion, relax or abandon. It is imposed by international law without any discrimination between one state and another. So the question of what the trial judge suggested, that somehow would be burdensome in some cases to have to make a determination absent the appearance of the state, we say is not a reason not to make the determination, both under the Act and under international law. And absent the determination, the court simply cannot proceed to perfect an order or to lift a stay on enforcement and so on, because it hasn't decided whether it has jurisdiction. I take your point, my lord, that in some cases that may be a formality in the absence of any further argument being heard. But in this case, it was not a formality, as I will show you in the facts. But I take your point, in some cases, there may be not much more to add. I'm not saying that the court must list a hearing in every case, but it must make a determination in every case. That is an extra step. We then go to the second proposition that is emphasised. So you have the point on no jurisdiction without determination. And the second proposition emphasised in the permission to appeal is that a court must determine on the balance of probabilities whether such an exception to the general immunity under the Act arises before it can proceed to consider the substantive claim. And it must make such, and there is no basis to suggest that this obligation differs where the state does not make a timely appearance. Now, I'm not going to go through all the authorities, my lord, but if I can go through the key ones. The first one is the judgment of the Court of Appeal in J.H. Rayner and Department of Trade and Industry. Now, this is in the other authorities bundle.
Yeah.
And tab 3. And we refer to, firstly, the findings of Lord Justice Kerr at page 194. E through G. And I'm looking at between F and H, where he says, in the upshot, therefore, I am persuaded that whenever the question arises under the Act of 1978, whether a defendant state is immune by virtue of Section 1, and I emphasise the following words, or not immune by virtue of one of the exceptions, then this question must be decided as a preliminary issue in favour of the plaintiff, in whatever form and by whatever procedure the court may consider appropriate, before the substantive action can proceed.
So just pausing there, if the judge had said, well, because the Federal Republic of Nigeria has failed to comply with the orders of the court as regards making an application, I'm going to proceed to deal with the issue as to whether or not there is state immunity on the basis of the material that I had before me at the ex parte stage, and I decide on a balance of probabilities that there is no state immunity. That would be enough, would it?
If she
it's the same point my lord made, really.
If she bona fide felt that she could proceed on the materials she had, but those materials didn't go into the detail of the issues arising. They didn't go into.
Well, they don't know. We don't know, do we? Because you were never.
All those materials are in
an application in time.
No, those materials in the ex parte application are part of the bundle.
Oh,
And it's
where
not
cross
suggested that
purposes.
she could decide on the basis of the bundle or on the papers.
Purposes, I think.
Yes. But what she would have been doing making the decision on the basis of the materials before her, which would be the ones on the ex parte application.
Well,
Yes. Which you say are partial and don't give the full picture, but that's because you haven't taken the opportunity to give the full picture.
well, I think we're jumping ahead a number of steps. The first thing is we don't know whether she would have felt comfortable proceeding on that basis.
No, we're testing the proposition.
Yes.
Because what
As a
Lord
matter of
Justice Carr
principle.
says is must be decided as a preliminary issue in favour of the plaintiff in whatever form and by whatever procedure the court may consider appropriate before the substantive action can
Yes.
proceed. So that begs the question, what procedure would have been appropriate here?
Yes, it
The
does.
judge might have said, well, the procedure that's appropriate is the one that I've already adopted on an ex parte basis, so I don't need to do more. Therefore, I've made the determination as a preliminary issue.
My lord, if I can just pause there, just to assist you, the previous paragraph makes clear that a good arguable case is not enough. But just going back to your question, it's such a speculative question you're asking me, my lord, because the judge proceeded on the basis that she did not need to make a determination.
I quite
So we
understand,
simply
but-
don't
but I
understand.
think you're missing the point. The point is not what actually happened. The point is conceptually, what would that be appropriate?
It could be, yes. And I just want to make it very clear, this is something that we disavowed in our skeleton. We are not suggesting that in every case there needs to be a trial or there needs to be a certain approach. All we are saying is that there needs to be a determination on the balance of probabilities. So your lordship should not see it as part of our case, that we are restricting courts in how they proceed with such cases where the state doesn't make an appearance. But what we are saying is that on the facts of the papers, they would need to proceed to make a determination. The error we have is that the judge proceeded on the basis, firstly, that she did not need to make a determination. And we say she fell into error there. We say it is unsafe to speculate what she would have done otherwise because she didn't say. And the second point is that she erred in law on the basis that she found that by way of sanction, she could assume that she had jurisdiction. She could assume, she could make a finding by way of sanction without making a determination that an exception under the Act applied. That is the scale of our appeal. And it may be that your concern is rightly that you're being asked to make a finding.
Did she actually say that?
Say what, my lord?
Did she actually say that because Denton and White applies, I have jurisdiction which I wouldn't otherwise have? I don't recall her actually saying that at all.
No, she doesn't say that. It was
So
put
how can
to
it be
her.
an error of law?
It was put to her that she could not have, by sanction, she could not avoid the determination. And I think in ground 2, all she said was that the sanctions regime applied because of the commentary in the White Book, and that is one of the grounds of appeal.
Okay. Right, so you're showing us Rayner. Do you want to show us?
If we just stay on Rayner briefly, my lord, and we go to 252.
Yeah, Rafe Gibson,
And we see Lord Justice Ralph Gibson, he at the start of the page, he talks about his agreement with Lord Justice Kerr. And then if we look around the letter E, he says, I would accept Mr. Pollock's submission that if proof of the exception to state immunity turned upon issues of fact, as in this case upon the matters dealt with by Mr. Justice Staunton, it did not. The court could give directions for the trial of those issues, including directions for discovery, for the calling of witnesses, cross-examination, so forth. The sovereign state could not be placed under any sanction with reference to discovery, but in deciding issues of fact, the court could have due regard to any failure to disclose relevant documents. And this passage is helpful because it helps clarify two misstatements of Nigeria's case. The first is that the requirement to make a determination doesn't mean that in every case there must be a trial, because obviously in J.H. Rayner, there weren't found to be any issues of fact that required that trial. And we're not suggesting otherwise. The second point that Lord Justice Ralph Gibson makes helps illustrate the difference between the court having to make a determination, which we say it must, and the court being the master of the procedure for that determination. So what Lord Justice Ralph Gibson says here is that the court can order discovery. It can't sanction enforcement in the absence of discovery because it has to make a determination. But it can certainly order discovery and make inferences if it requires. And the same would apply, for example, to the proposition that his lordship put to me, which was, well, what if a date was set for a determination after the time for an appearance had passed? And the state didn't attend that hearing. Yes, the court could proceed, but it would have to make a determination. And it's helpful in that light then to look at the Mauritius case, my lord, which is at tab 8.
Yeah.
It's the same bundle, my lord. Tab 8. Mauritius Tourism Promotion Authority, and this is MIN. And this is a case that's emphasised in the Commission to Appeal skeleton. And if we go to page 5, paragraph 10, the judgment...
If it's page 5, it can't be paragraph 10.
I'm so sorry, it's page 3. So sorry. Page 3, it's page 5.
Thank you.
Page 3. So the judgment is given on behalf of the Employment Appeal Tribunal by Mr. Justice Elias, who's sitting as the president. And he says, paragraph 10, once the time for lodging a response had elapsed, the case was considered by an employment judge, who of his own motion listed the matter for a pre-hearing review on the grounds that the tribunal might not have jurisdiction to hear the case because of state immunity. Accordingly, he did precisely what Section 1.2 envisages. He made an order which identified as a relevant issue whether the authority is a state or an emanation of the state for the purposes of the 1978 Act. And then at 12, he says, A preliminary hearing dealing with the issue took place on the 22nd of November 2006. The respondent was neither present at nor submitted any documents for the hearing. The employment judge heard evidence from the claimant and decided that there was no state immunity. The determination was then made as section 1.2 requires. And if we look at paragraph 13, what then happened is that the Mauritius High Commission wrote to the tribunal saying that it had immunity. Paragraph 14, the tribunal treated this as an application for review of the finding that there was no immunity and listed the review for a hearing. And if we go over the page, paragraphs 15 and 16, the High Commission again doesn't attend the review and the tribunal confirms its previous decision. At paragraph 17, neither of these decisions is appealed on time. There's then a substantive merits hearing, and then the High Commission seeks to appeal on the grounds of state immunity. And having made the determination, the Employment Appeal Tribunal very properly said, well, no, you don't get more time. And I think this case shows a tribunal or court looking at immunity of its own motion, determining it, and at the same time remaining the master of the procedure. We say those two things are not mutually exclusive. And if we look at page 11 of the judgment, my lords, paragraph 35, Mr. Justice Elias refers to the judgment of the Industrial Tribunal in United Arab Emirates, Abu Ghaffar, a judgment of Mr. Justice Mummery, as he then was. And then if we look at the top of page 12, there's a quote from that case, and I'm reading sort of 6 lines from the top, from the judgment of Mr. Justice Mummery. And he says, for present purposes, the important point of state immunity is that it is provided by section 1.2 of the Act, that the court itself has a positive duty to give effect to the immunity conferred by the Act, even in cases where the state does not appear in the proceedings in question. He then quotes the Act, and then he says, the decision of this appeal tribunal in Sengupta in India illustrates how seriously the court regards this obligation. In that case, the foreign state did not appear to take the point in jurisdiction. The court asked for the appointment of an amicus to assist it. If the court has a duty under statute to give effect to the immunity conferred, even though the state does not appear to claim it, that duty may be all the greater in a case where the foreign state, as is here, expressly taken the point of immunity. And then, similarly, although this is a tribunal case, we see at page 15, paragraph 48.
Sorry, where are we?
My lord, page 15. Paragraph
Page 15 of what, though?
Of the numbered pages in the judgment.
Oh, I see, so sorry, I've just done myself.
Paragraph
I've done
48.
Yep, thank you.
Oh, sorry. Mr. Justice Elias refers to J.H. Rayner, and then paragraph 51 over the page, he says, in this case, the court did raise a matter of immunity of its own motion. It also notified the authority of its initial decision and gave them every opportunity to counter the evidence which had been advanced on behalf of the claimant. It seems to us that this was the equivalent in the tribunal context to the kind of approach envisaged by the Court of Appeal in the Rayner case. So we rely on Mauritius as what we say is setting out what is a plain meaning of section 1.2. That regardless of whether or not the state makes an appearance, a court must give effect to immunity by determining on the civil standard whether or not an exception to immunity arises.
Can I, now you've had a chance to lay the ground
Yes.
a bit more, can I put you again the point I perhaps tried to put prematurely before? I understand your point about there being a necessity for a determination, but in a case where an ex parte order is made on the basis necessarily, because you wouldn't make an order otherwise, that on the evidence before it there did not appear to be a case for state immunity, but recognising that the putative state hadn't had the chance, the state hadn't had the chance to put a contrary case and put in place a procedure for allowing that to be set aside, which then isn't taken advantage of. Why is the correct analysis not that there was a determination? There was a determination at the ex parte stage on the basis of the material then available. None of the cases that you have referred us to so far, or that I've looked at in preparing for this, are analogous to this case. The nearest is the Mauritius case. There may be the distinction that you drew, but I'm not sure it's an essential distinction at all. The substance has got to be that there is a decision by the court that there isn't immunity. And why has that not occurred in this case, taking the procedure as a whole? When the ex parte order is granted, procedural mechanism is put in place which isn't then taken advantage of. Rather long-winded question, but you see the point I'm making.
Yes. Well, I think when we look at the factual papers, which I may jump to now, if I can take some of the authorities that follow as read, then we see that clearly there wasn't a determination by the.
It all depends what you mean by determination. But
yes. Well, we say the determination must be on the balance of probabilities, on the civil standard of proof, and that once we see the authorities that are very clear on that, there is no basis for suggesting that a varying standard of proof applies.
We'll look at the authorities in a moment if you want to take us to them, I'm sure. But again, are they dealing with this kind of situation?
Well, they're not specifically dealing with this kind of situation, but the moment you accept, and we say must be right, that state immunity precludes a jurisdiction, absent an exception, then the court can't just assume a jurisdiction.
But it's not assuming it, it's making a finding on the basis. So I don't want to argue the case, but just to make sure you've understood what I'm putting to you. The court has in fact made a determination on the basis of the material before it.
Yes, but
on the balance of probabilities.
Well, that's where we would say there hasn't been.
Well, I'm not even sure that's, I remain to be shown that that's necessary, but let's assume you're right about that.
Yes, there plainly has not been a finding on the balance.
I put my point to you, and I understand you want to develop it once we've seen what actually happened in this case. So I'll shut up.
But my lord, I think if we were talking about a different case where the judge said in the ex parte order, I've looked at all the live issues, I am able to decide comfortably on the balance of probabilities, subject to anything anyone else has to say, the state has to say, that there is an exception, then we may be in an interesting space. That is not what happened here. I struggle to see how any judge could properly do that, because the Act itself says that the state has to be given 2 months to make an appearance. So for them to be making any kind of determination without allowing time for the appearance...
It's making, as it were, a provisional determination. The determination will lapse if within the time allowed an appearance is made and a point is taken.
Yes, I think that if that were done, it would not be proper, because it would not meet the requirements of the Act or the law, because the courts are very clear that a good arguable case is not good enough. It must be a finding of the exception.
Let's assume that,
and it must be a reasoned finding.
let's assume that, as in Mauritius, your clients and the judge had fixed a hearing and your clients hadn't turned up. Why couldn't the judge simply have said, well, for all the reasons I gave when I granted the ex parte order, it seems to me state immunity doesn't apply on the balance of probabilities?
Well, the judge could say that. If that was a proper decision that he or she could reach on the facts, then it would be appealed in the normal course. But that is not what happened here. It's not simply the judge going through, obviously no one's suggesting that, I'm just extending the point, but no one's going to suggest that the judge should go through something that he does not believe is a genuine inquiry into the matters alive before him or her. And then he or she would give a reasoned determination, which would then be subject to appeal in the normal course. The difficulty you have is what happened here, which is you say, the judge says, I don't need to make a determination unless you convince me that you are entitled to relief from sanction.
Well, let's see what the judge did say. I just wanted to...
Yes, of course.
Okay, right. So what other authorities do you want to refer us to?
I'll try and be quick because I'm mindful of the time. If we look at, now go to the supplemental authorities. tab 2.
ETI Euro Telecom.
Yes, it's ETI in Bolivia. And if we start with the judgment of Lord Justice Lawrence Collins at page 689 of the report, which should be page 53 of the bundle. And 110, Lord Justice Collins says, I come to this point last simply because it was treated in that way by the judge and by the parties on this appeal, but it is in fact a matter of the greatest importance, as made clear by the provision of Section 1 of the State Immunity Act, that the court must give effect to immunity even if the state does not appear, and would normally fall to be considered first. I am satisfied that Bolivia is entitled to immunity and that the appeal on this ground fails. The point of interest is in the judgment of Lord Justice Stanley Burton at the last page, 693, this authority, page 57. He says at paragraph 128, last, I would wish to commend the judge's decision to hear the jurisdictional issues when he did. Any claimant who wishes to bring proceedings against the state must be in a position to address the issue as to the jurisdiction of the court when he seeks to invoke the jurisdiction of the court. If he seeks an injunction against the state on an application without notice, he must do so then. The court must then consider the question of state immunity, since it is required by Section 1(2) of the Act to give effect to the immunity even if the state does not appear. So there is a positive duty on a claimant against the state, as is evident under the Act, to explain why an exception to state immunity arises. So when the court is faced with that claim, it becomes a live issue. It's not something that can simply be only become alive if a state asserts state immunity. If the claim is against a state, the claimant is expected to explain to the court why an exception to state immunity arises. And that triggers the obligation to determine it, and it triggers the burden of proof on the claimant to satisfy the civil standard. And we said that there is an artifice, a wrongful artifice, seeking to draw a distinction between where a state claims immunity or where a claimant asserts an exception to immunity. The question is still the same. Does the court have jurisdiction? And the standard of proof must be the same.
But what he's contemplating there is that on an application to the judge ex parte for a freezing injunction against the state, the claimant has to put forward a case to the effect that state immunity doesn't apply, and the judge will make a determination as to whether it does or doesn't.
Yes.
But what he's not saying is if that's where the matter rests for whatever reason, then you have to go on to make yet further, as it were, pointless determination later.
Well,
if the state simply allows the freezing injunction to remain in place, the commercial court will have made a determination, albeit on the material that was before it, that state immunity didn't apply. Now we can debate whether that's a prima facie case, a good arguable case, on the balance of probabilities. But the fact is that I can't see any earthly reason why there would need to be a further determination in that example.
The point of 128 is this. It suggested that till the state appears to assert immunity, the issue of immunity somehow is dormant. But there is a positive obligation on a claimant, which a court obviously will be alive to, if it sues a state, to raise the issue of state immunity itself. So it becomes a live issue.
And that's exactly what happened here.
Yes, and what we say is that if you look at J.H. Rayner, it talks about an obligation to determine on the civil standard, he uses the word, whenever the question arises. And we say the question must arise every time there is a claim against a state. I think you're positing a different issue, which is what is the status of a freezing order, which is made ex parte.
But it's the same point with respect, Mr. Hussain.
Well,
Just as an application to enforce an arbitration award is made in the first instance ex parte. on the
Well,
papers.
it's not the same point, my lord, because a freezing order, obviously, you can come and resist it as and when you want to resist it. But in this case, what was found was, well, if you didn't make an appearance in time, by way of sanction, the court was able to order a final enforcement. That is the difference. And we say you shouldn't, we're not resisting the ex parte order. But we're saying, which was made with a stay, we're saying in order to lift the stay.
If the court had said in the freezing injunction case that any application to vary the order is to be made within 28 days, or 2 months and 2.5 months, whatever the period was here, and the state then turns up 6 months later,
Well, I'm
why
not sure
isn't
you,
the court
yeah.
entitled to say you're too late, you haven't complied with the rules?
I'm not sure you can do that in a freezing order, which is continuing, but yeah, possibly yes. But the fact is
Well, you
that
may not be able to do it specifically, although I think I can think of situations where that might apply.
well, no, when you make a enforcement order with a stay, you have to then lift the stay. So the point we seem to be talking about is the procedural difficulties it would cause to have a second determination. And the point we make is, firstly, that that's fine. We appreciate that they would possibly be burdensome in some cases, although we're not being prescriptive as to what needs to be done.
Okay.
But international law makes clear the importance of state immunity. But you would need to come back to lift the stay in any case, if we're looking at if the burden were material, which we say it isn't. And then, if we look at a case that the respondent refers to, which is at tab 6 in the same bundle you're looking at. It's A and X.
Yeah.
Sorry, I've now got both authorities open. Which bundle?
It's the one that has the Act as the first tab.
Okay,
It's
thank
called
you, yes.
supplemental.
Yeah.
If we go to page, so we're looking at A and X. We go to page 524.
Yeah.
And this is the judgment of Mr. Justice Saville. So there remains one final matter. This is the last paragraph of the second column of 524. There remains one final matter, which is how the court should deal with cases where moravian injunctive relief is granted against the state, which then applies to discharge or vary the injunction on grounds relating to sovereign rights, including its rights in respect of diplomatic immunity. It is clear that when a state seeks to rely on the general immunity conferred by Section 1 of the State Immunity Act, the court must finally decide at the outset whether or not such immunity exists. And he refers to J.H. Rayner. McLean Watson is the same case.
No, that's the Tin Council case.
Yes.
It's the same judges, as
Yes.
it happens. It's Lord Justice Carr and Lord Justice Ray Gibson, but it's a different case.
Okay, well,
And
that might be
and
error on my
it's
part.
simply, I mean, I don't think it goes, I looked at those passages, I don't think they really go any further than what Mr. Justice Saville says.
I'm grateful, my lord. That's my mistake. Thus, when a state seeks to discharge a moravian injunction on the grounds that it is immune from the jurisdiction of the courts of the UK, the court cannot allow the injunction to continue on the basis that the plaintiff has a good arguable case that immunity does not exist. Or if in truth immunity does exist, then the court simply has no power to continue the injunction. We say the same applies here. This is a very clear statement that there is no exception from the approach in J.H. Rayner to ex parte applications for the simple underlying reason that absent an exception to immunity, the court has no jurisdiction. And we say it is wrong to suggest that somehow a sanction can trump that. We don't think this case assists the respondent. In fact, it repeats the application of the general principles to ex parte orders. And just to emphasise that, if we go to the next, I'm sorry to make you jump, my lords, but if we go back to the other bundle, the other authorities bundle. This is tab 7. I'm so sorry to jump between bundles. It's tab 7. It's a case called Hulley and Russia. case before Mr. Justice Henshaw.
Yeah.
And then if we go to the page 3495 in the report.
Yeah.
At paragraph 222, Mr. Justice Henshaw quotes the Act, and then he says,
Yeah.
thus, pending any finding that one of the exceptions in the Act applies, the immunities from the court's jurisdiction in general, adjudicative, and as well as enforcement. And then he says it is well established that where a question of state immunities arises, it must be decided as a preliminary issue. He refers to J.H. Rayner. And then if we go over the page, 225, he refers to ETI in Bolivia, which I took you to. And then he refers to, at 226, an unreported judgment of Mr. Justice Saville, who was a judge in the ANX case. And he quotes from that.
So sorry, which paragraph are we now on?
226.
226. I'm sorry for rushing on. So this is Mr. Justice Henshaw quoting from a
Yes, I've written that, thank you.
unreported judgment A and B of Mr. Justice Saville, who was a judge in ANX that I just took you to.
Right.
And if we look at the quote at item G of the next page, 3497, he says, if under the State Immunity Act, a foreign sovereign is immune from the jurisdiction of the UK courts, that is the end of the matter.
I haven't found it yet. Letter what?
Sorry, G. I'm so sorry.
G.
It's 3497G. It says, if under the State Immunity Act, a foreign sovereign is immune from the jurisdiction of the UK courts, that is the end of the matter. In such a case, the court has no power to decide whether or not, for example, England is a convenient forum, nor any other questions that might arise in the context of litigation. And then over the page, helpfully, he says, this is still Mr. Justice Saville, in A and B, it is for this reason that I concluded in A and X that when a question of state immunity arises, it must be finally determined at the outset, relying on the decision of the Court of Appeal in J.H. Rayner. It is not permissible to proceed on the basis that the point can be determined later. For if immunity in fact exists, the court would ex hypothesi be purporting to exercise powers which it does not possess. There are two objections to the case below. The first is the failure to make a determination, and the second is the finding that the sanction regime under CPR 3.9 can apply in place of such a determination. And finally, this is the last case I'll go to, and then I'll go quickly through the facts. I'm mindful of the time.
Yeah.
If we go to a judgment that was reported just a couple of days after, I think, the decision below, which is now back in the supplemental authorities bundle. I'm so sorry. No, it's in the bundle you just had. I'm so sorry, my lord.
What tab?
Tab 1. Apologies.
Corinna.
Yes. And we look at the judgment of Lady Justice Semler, yes, who gave the sole judgment, I believe, or with whom the other lordships agreed. Paragraph 13, which is, I'm sorry, this report is not paginated, I apologise. It's paragraph 13. She says, as a matter of domestic law, because the SIA is a complete code, if the case does not fall within one of the express statutory exceptions, the state is immune. We say that this is common. This is a common understanding, and therefore a sanction cannot create an exception to immunity.
Sorry, that's a comment by you.
Yes, so we said.
It's not. This wasn't a case about sanction at all.
No, it wasn't.
So what are you referring it to us for?
That the SIA is a complete code to the exceptions to state immunity. So in order for there to be an exception to immunity, the state's general immunity, it must be...
Is that in dispute? Maybe it is.
Well, If it's not in dispute, then it's difficult to see how.
What's in dispute is whether or not by applying the sanctions under the CPR to somebody who hadn't complied with the rules, you say, well, that creates an additional exception which isn't within the State Immunity Act. What Mr. Harris says is, no, that's not the case. And
Yes.
nowhere does the judge say so.
Well, the judge, okay. Perhaps I'll come to that then when I look at that, but that is.
But it's simply it all depends on whether you're right on your main point, but you have already accepted, as I understand it, that as long as there is a determination, the procedural route to that determination is a matter for the court, and it must follow from that, mustn't it, that if the procedural route is set and then not complied with, that's not an exception to the State Immunity Act. It's simply a application of the procedural regime which you accept must apply to issues under the State Immunity Act.
I accept that the court is free to set a procedure for how it makes the
Yes,
determination.
and that must mean to apply sanctions for failure to comply with that procedure.
Yes, but the sanctions cannot be a substitute for the determination themselves. That's
That I accept, but speaking for myself at this stage and so on, that's, if you're not right on the first point, that's not what happened here.
on the first point being that there was no determination.
Yes.
Yes, if I'm not right, yes.
Okay.
And then we look
Is
at.
there anything else in this Juan Carlos case we need to look at?
Yes, 21, which is further down. If state immunity is established, it is for a claimant to establish to the civil standard an exception to that immunity, for example, under whatever the exception is. And then 22, whenever the question arises under the SIA as to whether a state is immune by virtue of section 1 or not immune by virtue of one of the exceptions, the question must be decided as a preliminary issue in favour of the claimant. And she repeats the passage in J.H. Rayner. The point is that there seems to be, certainly from the appellate judge's position, that there is a prima facie finding suffices in the absence of an appearance by the state, but a civil standard determination will be required if the state appears. And we say that there is no basis, both as a matter of law and
We're
authority.
making a distinction between prima facie and civil standard.
Yes.
But why shouldn't a prima facie finding be to the civil standard?
Because
Suppose the judge had, at the time he made the original order, produced a short paragraph of reasons and had said, this is a case where there is where prima facie the State Immunity Act applies because it's a claim against the state. Whether state immunity, I therefore have to determine whether one of the exceptions applies. I've seen the material that has been supplied by the applicant, which convinces me to the civil standard that it doesn't apply. None of the exemptions don't apply. But I appreciate I haven't yet heard from the other side, so this decision will be provisional in the sense that they'll have the opportunity to set it aside. If they don't, my determination will stand. Now, suppose she'd written all that out. Would that be objectionable? And if so, why?
I think that's quite a broad question. It may
It's
not
not,
be
it's a very
objectionable.
specific question.
Well, it would depend on whether she could properly do that.
Yes, but okay, suppose she did do that, say she'd done that,
Yes.
and properly did that.
Yes.
Because on the material before her, it would hardly be very surprising. On the material before her, she was satisfied to the civil standard. Wouldn't be surprising because perfectly short but effective reasons were given. I'm not arguing about the facts of this case. I'm just trying to see conceptually whether that's something you couldn't do.
Well, well, conceptually, depending on whether it was a fact-heavy case or not, and we say this was a fact-heavy case, I would be surprised if a judge put that on paper before allowing the 2 months for the appearance to lapse.
Why? Why would you be surprised?
Because it would seem like prejudging the issue, possibly.
But whenever you make a prima facie decision, you're prejudging the issue,
Yes.
but you're not definitively doing
Yes.
so. You're doing it on a provisional basis.
I don't think in its essence, it would, subject to the facts, it would be objectionable. But the judge would still need to make a determination after the time for the appearance had passed.
Well, I'm wondering, see, that's what I'm just testing with you. She has already made a determination, but on a provisional basis, or if you like, a conditional basis, the condition being that there's no application to put further material before the court which might lead to a different conclusion. If that condition isn't satisfied, the original determination ceases to be provisional and becomes determinative. There's nothing wrong with that as a matter of justice, and at the moment I can't see there's anything wrong with it as a matter of the principles under the 1978 Act.
And equally, that's in effect what the judge did here, because what the judge did was to make an order on the, which she could only have made on the basis that she was satisfied that the claimants showed a case that a sufficiently arguable case that the State Immunity Act didn't apply, but said you had a period of time in which to make an application if you wanted to. It's paragraphs 4 and 5. And in the meantime, the enforcement was stayed until such time as...
Yes, I know what Mr. Hussein's going to say. He's going to pick up the phrase sufficiently arguable and say that's not...
Well, I understand that point as well.
But it's a distinction without a difference in this particular context, isn't it? Because where the evidence only goes one way, a sufficiently arguable case will also be, until there's any other evidence, a decision to the civil standard.
I don't see a sufficiently arguable or a good arguable case to be the same as on the balance of probabilities.
No.
And
Conceptually, they're not, but in substance, in particular circumstances, they may be.
I can't agree with that, my lord. I think that the good arguable case and balance of probabilities are two very different standards.
They are.
And that is disavowed by the court.
But on the facts on one particular case, you may satisfy both.
That may or may not be the case, but that does not mean that they are the same. And certainly a prima facie case would be, well, yes, there is an arbitration.
I'm afraid in the example I put to you, you'll say, these are the facts here, but I'm just testing it. The example I put to you, the judge in her reasons at the time said, I have looked at the material and I'm satisfied to the civil standard.
Yes, then you know,
I think you accepted.
There would be nothing objectionable in her saying that, but then she would need to revisit that by way of something, whether it's a finalisation.
You need to revisit that if, within the procedural timetable that she then set down, further evidence counter evidence in practice, were put in by the defendant, but not otherwise. If the procedural timetable were not satisfied, then she could rest with her original decision, which on the case I'm putting to you was explicitly to the civil standard.
I can see that in principle being okay, but it's very far removed from...
And if you look at what the judge said in paragraph 4 of her judgment, which you're seeking to appeal, she refers to the procedure and she makes the point that she had made an ex parte order on the understanding, on the basis of the issues about state immunity being ventilated before her, in order to give your clients the opportunity to come back and say that there was no jurisdiction because of state immunity. And she makes the point that that's not an unusual way of proceeding, which I can confirm from my own experience as a commercial court judge. But that in some cases, the court will, looking at the material that's put before it, the court may say, well, this is sufficiently unclear to me. There may very well be a state immunity argument here. that I think I'm not prepared to make an ex parte order. I'm going to say there should be a hearing. And at that point, there would of course be a full hearing if the state comes in, assume the state comes in. There would then be a full hearing and a determination of the kind that Rayner refers to. But I think what we're trying to test you on is whether somehow the way in which the judge proceeded, which is a normal way of proceeding procedurally, was somehow defective, or that she had to do something else other than what she did.
Well, I'm not challenging the way she proceeded, because obviously the enforcement order was subject to a stay.
Yeah.
But there is no case that anyone has been able to find.
What you're saying is that she had to make some further and better determination at some stage,
She had to make a determination on the
even
civil.
though your clients had not actually complied with the rules.
Yes, I am saying that.
So perhaps I can just test this. Again, you'll say she didn't do this, but please don't say that. I want to know what your answer is if she had said it. If at the end of the period you hadn't appeared, she had written a 2-sentence judgment saying no further material having been, no application having been made, and therefore no evidence have been provided to contest my provisional view on the ex parte basis, I hereby determine that state immunity does not apply. That would have been unobjectionable.
Yes, would have been subject to appeal.
Well, of course, subject to appeal, but in principle,
but
unobjectionable.
When your lordship's put to me,
Well, what would the basis of the appeal been?
well, that on the papers before her she made an error or whatever.
What error in that example?
Well, I don't know, because it's such a hypothetical example, but it would certainly be subject to the regime of appeal. That is why you need a determination.
Hang on a moment. Let's assume the judge makes an order. What my lord's asking you to focus on. Look at the order the judge made. It gave 2 months and 14 days to make an application to set aside the order she'd made ex parte. And this is on the assumption that you don't bother to do anything. You just don't turn up at all. So after about another, I don't know, let's say another month or however long, there's an application made by Mr. Harris to set aside to lift the stay.
Mm-hmm.
The judge then delivers the short judgment that my lord's referred to. What on earth would be the basis for going to the Court of Appeal about that? You entirely, in that example, the author of your own misfortune by not bothering to make an application under paragraphs 4 and 5 of the order. But the judge will have made the determination that you say is a prerequisite under the state immunity.
I think, Mr. Hussain, you say, have I got this right, that suppose you then looked at the material that was before the judge at the ex parte stage, which had never changed thereafter, and it was patently flimsy, so that even allowing all, making proper allowances for the judge's role as fact finder, a proper finding of fact on the civil standard, even on the one-sided evidence put forward, could not have been made, then you could appeal on that basis.
Yes, I mean, to give you a very real example, one of the key issues in the arbitration was whether by going to court prior to starting the arbitration, the investor had fallen foul of the fork in the road clause, which required them to elect between court or arbitration. And the arbitral tribunal found that it had not fallen foul of that, because it took a certain view of what that clause meant and what the court actions meant. Now, if the judge in this hypothetical example gave a judgment, which he didn't, saying, I determine that this is right, that the arbitral tribunal is right, then that would be subject to an appeal on the basis of the reading of the contract and so on and so forth. And that is why the determination is important. I keep being told to hypothesize that there was a determination, but no one is able to point to where that determination lies. Where are the reasons for it?
Well,
where is it recorded?
There is a provisional determination at the time she makes the ex parte order. There are no reasons for it, because since at that point it hasn't been contested, there's no particular reason for any reasons.
Well, there is no document that says I hereby determine whether...
No, I know there isn't,
Yes.
but it's
So,
implicit
I mean,
in the order made. If she hadn't determined it, she wouldn't have made the order.
well, that,
Which is the point she makes at paragraph 4 of her judgment.
if it's been suggested that there can be an implicit determination that can neither be read nor understood, then I say that is wrong. And I don't think that the judge suggested.
Well, the answer is to apply. And then normally there's none of this elaborate analysis would be necessary if only you'd taken the simple step of apply in the time provided for. It's only because you didn't do so that we're having to look at it in this rather artificial way.
I appreciate that. That is a context, but also, I mean, the flip side could be that because the judge refused to make a determination or issue a determination that we are here today.
You refused, but anyway, it's too late.
But I would, before I move to the facts, I do want to stress something, speaking frankly to the court, and I hope this is taken the right way. My concern is that the emphasis is too much on the burden on the courts, and not the starting point must be, in my submission, what is a requirement under the Act? Can the court have jurisdiction under international law and under the Act without a finding that an exception exists? And the passage I took you to in Jones in Saudi Arabia is very clear that you can't, it's not a jurisdiction that you withhold, it is a jurisdiction that either exists or not, and it can't be tailored to your...
Speaking for myself, I have no difficulty with that, but the question is how that principle applies in the particular situation we have here, which is not paralleled in any case of the cases you've shown us.
Yes, and there is no case where a court has declined to make a determination or not made a determination based on the fact that the appearance is too late. So the flip side also applies. I would imagine that in most cases the court would proceed.
Well, then one might say, what is the correct principle having regard to the spirit of the Act and indeed of international law, which it reflects? And
yes.
if you look at that, you might find that that wasn't very helpful to you. Because all the important points you've made about determination, the importance of determination, are made in a different context.
But the context is simply the facts of that case. That the fact is that if you take as the underlying point that there is no jurisdiction absent a finding of an exception, then the finding of an exception must be there. And in fact, I would say that the suggestion that the requirements vary according to whether or not the state makes an appearance is contrary to Section 1.2. The plain wording of Section 1.2 is that the court must give effect to immunity, regardless of whether or not the state makes an appearance. But I think I've assisted you on the law as much as I
Yeah, you have. It's
could.
been very helpful.
If I can then move on to the key facts. And the three facts that I wanted to emphasise. First, that Zhongsan's ex parte application positively averred an exception to state immunity under the Act. Second, that the judge did not determine on the civil standard whether the exception arises. And the third point was really one for the 52.30 application, that the PTA looks at the law in more detail or looks at more cases than were put to the judge, but that's not something I'll focus on for now. If we look at the ex parte application, my lords, this is in the appeal bundle. At tab 9. And we see at page 118, we see the first witness statement of Dr. Kovacs on behalf of the claimant. And then if we go to page 123, paragraph 3.3, Mr. Kovacs notifies the tribunal of a number of arguments that Nigeria asserted, that Zhongsan's claims were not concerned with the conduct of Nigeria. 3.3.2, there was not an investment within the meaning of the treaty. And then we see the reference to the fork in the road argument.
Yeah.
And so on. We then see at page 126.
Yes. So we should look at 124 where he sets out what the tribunal decided on what
Paragraph 3.4, it sets out what the tribunal said in answer to those points.
Yes.
Yeah.
But then when we come to these were still points that were being challenged by Nigeria, they were not accepted. And we'll see if we go to page 126. Paragraph 6.2.3, the common
Yes, I mean,
ground.
obviously we have to note that 5, Mr. Kovacs explains the discontinuance of the Section 67 challenge, but
Yes,
yes.
but again, you have my case on this under the previous act, which says that does not, it's a case on nearly identical terms, Duff developments, where a challenge to arbitration that is withdrawn does not waive an immunity argument.
Yes, I
or enforcement argument.
I wasn't referring to it as a waiver, but
Yeah.
simply as part of the material before the judge, in which he could judge the merits of such immunity claim as might be advanced. It would be a relevant consideration, though certainly not determinative, that an attempt had been made to advance such a claim, and it had been discontinued. That's my point.
It had been withdrawn by agreement. I'm not sure what, if any, evidential value could be placed on that. Yes, that is a fact.
Anyway, sorry, you were about to take us to 6.
Yes. If we then go to 6.2.3, it's accepted that Nigeria is a state in accordance with the Act, or under the meaning of the Act. And then page 127, the draft order also provides that if Nigeria makes an application to set aside the order on grounds of state immunity, then it will have a further 14 days from the date on which the immunity application is determined to apply to set aside the order. So it anticipates a possibility of a state immunity argument. And then, and 7.2, the possibility that Nigeria may argue that it is immune from the court's jurisdiction. It says it does not think that would be meritorious. It says Nigeria might contend that Section 9 of the Act does not apply here. And he gives it the reasons that may be raised based on arguments raised consistently, I would add, through the arbitration. One of them is Zhongsan failed to make a qualifying investment within the meaning given to that word by the BIT. And then the fork in the road clause. And then he says, importantly, although a matter for, this is 7.5, although a matter for submission in due course, I do not consider that any such argument is likely to succeed for the reasons above. It's not been, even the claimant did not suggest that a view could be taken at this stage on the papers on the ex parte application.
It goes on to say that because you made the Section 67 application and then withdrawn it, to come back later and effectively try to run the same points again would be an abusive process.
And we say that simply is wrong. Raising an immunity is not an abusive process, and we can look at that as a separate point. But the fact is that on whether or not there is...
Why wouldn't it be possible for the court to have said, the arbitrators have decided that you were parties to an arbitration agreement to which therefore Section 9 of the Arbitration Act, the State Immunity Act provides an exception. Your client sought to challenge the jurisdiction of the arbitrators under Section 67, withdrew that application to the extent that they're now trying to rerun the same arguments under the State Immunity Act. It's an abusive process. Therefore, all the more reason why Section 9 applies.
Abusive process, my lord, is not an exception to state immunity under the Act.
It's not a question of an exception, it's another example of the procedure that the court can deploy as part of its procedural safeguards to ensure that any application in relation to whether or not an exception applies is properly dealt with, and not simply dealt with on the basis of the whim of the state in question.
Well, I'm not disagreeing with you that the court is a master of the procedure. However, abuse of process, as alleged, would not be a substitute for determining whether or not an exception under the Act applies. Secondly, whether or not there was an abuse of process, we have obviously made submissions on this, is simply not something that is established or, in our case, strongly arguable, given that in Duff developments, the same conduct was seen as not waiving immunity nor as an abuse of process. Raising the point that the court does not have jurisdiction is a factual point. That cannot be an abuse of process. The court either has jurisdiction or it doesn't. It either has jurisdiction against the state or it doesn't. It cannot.
But the basis on which the court would determine that there was an abuse of process would be that you wouldn't be entitled to run the point.
The court would still need to satisfy
And then
itself.
the court would decide that section 9 applied. What's wrong with that?
It is wrong, my lord, because whether or not the court has jurisdiction,
Well, on that hypothesis, the court would have jurisdiction.
on what hypothesis that there was an abuse of process and therefore the court has
That
jurisdiction?
section 9, that the effect of what had happened was that there was a section 9, an answer for the claimants under section 9 on a balance of probabilities, or any other standard you want to apply.
Well, my lord, if we just go back to page 127 and we look at the likely arguments at 7.4.3, none of these are argued by, these are all factual questions and legal questions, none of these are answered by an alleged abuse of process. The court cannot proceed just on general prejudice against a client. And to be fair, the judges didn't suggest she was doing what you've postulated. There is no suggestion in this application that the court can or should proceed to decide the matter on the papers. In fact, the papers don't allow that. They don't go into or provide the details of the evidence even that was submitted in the arbitration. And if we look at...
I'm sorry to
No, it's
just press you on this, but if you look at paragraph 5.1, what Dr. Perlash does there is to set out in summary what the arguments were that your clients were running under the section 67 challenge. And they're precisely the same arguments as he then summarises in paragraph 7.4. Aren't they?
Yes.
They're identical.
What is the point you
Well,
are...
the point I'm making is that's why he says, well, having tried to run the point of section 67 and withdrawn it would be abusive to try and come back and run the same points. Anyway.
Sorry, it's really important that we don't conflate two completely different issues. One is whether or not on these papers the judge was able to and did make a determination of whether an exception to state immunity applies, and I say didn't. Your Lordship is postulating a different question, whether she could exclude an argument to the contrary on the basis of an abusive process. And we say no, she couldn't, because an abusive process is not a grounds for the court having jurisdiction against the state. It either has jurisdiction or it doesn't. And the second point is obviously there has not been a finding of an abusive process. The only time the abusive process becomes relevant is if Denton applies, and we say it doesn't. If it applies, she put this in the mix.
Is there another argument as to why the arbitrators didn't have jurisdiction, therefore why you weren't parties to an arbitration agreement to section 60, to which section 9 applies, that isn't fairly summarised in this witness statement?
So the first point is that I think it should be uncontroversial that Nigeria is not bound to, in raising a state immunity defence, is not bound to what it raised before the arbitrators. If you're asking me, is there another
I want to know whether, if the judge had allowed you to run your challenge under the State Immunity Act, you would have been running different arguments to these ones.
There's at least one argument that the tribunal shut out because it said it was raised too late in the arbitration. These would be the arguments we would be running. I don't know whether we would raise additional ones.
Okay, thank you. Right.
But the fact is that the judge was not asked to, nor did she proceed to, decide or determine these arguments. And the suggestion that simply by issuing the ex parte order, which is in the form suggested by Dr. Kovacs, which is perfectly proper, she made some implicit determination, we say, is wrong. if we look at the order itself, it is in tab 7, so it's a preceding tab. And we're looking at page 109.
Yeah.
There is nowhere in the order that the judge says that she has made a determination on any basis of whether an exception to state immunity arises. And again, as drafted, I understand, by Zhongsan, judge allows in paragraph item 5 time to apply to set aside the order on the grounds of immunity, and then says that if that is done, then a further period of time shall arise after the immunity issue is determined. There's certainly no determination at ex parte stage, we say. And then when we look at the judgment in December of last year, and I don't think it's suggested that there was a determination at that stage. We look at paragraph 12, which is page 100 of judgment.
Page 100, yes.
Of 100, I'm so sorry, 100 of the bundle.
Yeah.
The claimant avers that it made certain investments in Ogun State. The fact of those investments is disputed. It is not disputed that Nigeria is a sovereign and independent state. That gives rise to the question of immunity. And again, you recall that in J.H. Rayner, the dicta adopted in subsequent cases is that whenever the question of state immunity arises, it must be determined. The question of immunity was to some extent live in the arbitration. This is a point which the Federal Republic has prayed in aid in its skeleton, showing me the points which were run. It was also a point which was made in the enforcement application by the claimant, which pointed out that the points underpinning immunity arguments had been run and dismissed by the tribunal in the arbitration. Therefore, the question of immunity was raised by way of full and frank disclosure by reference to what had already happened in the arbitration.
Mm-hmm.
And then she says in paragraph 16, so far as this first point goes, the Federal Republic has argued that because of section 1.2, and she quotes it, and because immunity is not dependent on a claim by the state, the courts have repeatedly recognised that the determination of a prima facie immunity under the State Immunity Act should not be shut out by procedural rules that would otherwise apply. And then she talks about the reference to various cases and Fox and Webb. Now, paragraph 20, she says, I am, as indicated in the course of argument, unimpressed by this argument, which amounts, taken to its logical conclusion, although that was disavowed by Mr. Hussein's case in argument, to an assertion that procedural rules do not apply to any state which may conceivably wish to raise state immunity issues, or to any case where there is a state involved which might conceivably raise state immunity issues.
Sorry, I was just pushing at something else.
I'm sorry,
where are you reading from? It's my fault.
I'm sorry, my lord.
Paragraph
I should be
20.
looking up. It's
Paragraph 20, yep, thank you.
Yeah.
I'll let you read that first sentence.
Yeah.
She says it amounts to an assertion that in the context of enforcement against states, this court would on any analysis be bound to schedule some sort of state immunity hearing, even if no argument was raised by the state of any sort. That is not, it seems to me, a set of propositions which is justified by the cases. And that is not something that we are suggesting. We're not being prescriptive as to the procedure, or seeking to be prescriptive as to the procedure for a determination. But a determination must, we say, be reached. And then she says at paragraph 29, to the extent it was submitted, and I think it was submitted, that the enforcement process needs to incorporate a process whereby the court deals with immunity of its own motion, I would be of the view that any further consideration beyond that involved in the application is unworkable. In a number of cases, issues will be apparent on the face of the application, and the court may then, as I've indicated, require there to be service of the application before an ex parte order is made. But it is also the case that sometimes immunity arguments are apparent, they are raised, they are described, and a prima facie case for non-application of state immunity is made, and that is regarded as sufficient to give an ex parte enforcement order. That process is not a case of the court disregarding its duty. It would, in my judgment, be entirely unworkable for there to be a responsibility of the court to embark in every case upon a process of considering each state immunity argument which is not taken, rather than simply confining itself to the structure which is in place at the moment. And again, I emphasise, we are not suggesting that the court refrain from issuing an ex parte order on the basis of a good arguable case, so on.
So are you in fact suggesting there's anything wrong with what she says in paragraph 29?
Yes, the first sentence, that to the extent it's submitted that the enforcement process needs to incorporate a process whereby the court deals with immunity of its own motion. She says nothing further needs to happen. If we look at the paragraph above, she quotes Fox and Webb, talking about a different issue, which is giving 2 months to make an appearance. And he said that is not a substitute. Allowing for an appearance is not a substitute for making a determination.
Right. So, you say there's nothing wrong in making an ex parte order of the kind made here. Why do you say there's nothing? Surely the nature of your argument is there has been no determination, and therefore an order couldn't be made, even with a set aside provision in it.
Because a set aside order is subject to a stay. Sorry, I should have been clearer. As long as it's subject to a stay.
But still, precisely. So the stay, effectively, an order with a stay, you say, is effectively written water. Because it's not an order, it doesn't have any effect at all. Is that the stay is crucial to your argument?
Yes.
Yes. Yeah. Okay. Thank you.
Right.
It's just as my learner junior has currently shown me, if we go back to paragraph 4,
Yeah.
she talks about the Nigeria wishing to bring a challenge on state immunity. She then says, I should note in passing that the possibility of such an argument being raised was noted in the ex parte application and duly reflected in the order which I made, which provided for a further period for other issues to be raised by way of challenge. She then says, I nonetheless granted the ex parte order, despite the indication that there might be a state immunity challenge, because what was said there about the arguments which were in play, including, and I emphasise this word, their potential merits. So she hadn't decided the merits.
Well, I thought that's entirely consistent with the analysis my lord and I were putting to you. She had decided them. She looked at the merits. She said, "This is one of these cases where I shouldn't do nothing and simply direct a hearing. The merits are sufficiently strong for me to make an ex parte order subject to a stay and with a procedure." Now, you will say she doesn't say this in terms, but you could say that is effectively a finding or a determination that unless anything to the contrary is shown, there is no case of immunity.
I think where I'm different from you is the use of the words, unless anything to the contrary is shown. It's subject to a review, an actual review of the merits. This is just looking at the merits of face value, prima facie.
Right.
So that is, she said, sufficient for issuing an order subject to a stay, and we don't oppose that.
Right. No, well, I think we're saying the same thing.
But what is clear is that she's not
Sorry.
suggesting that she has determined the merit.
She isn't using the word determined, but
Well-
that's for us. The word determined doesn't appear in the Act. So it's a barrier that you have erected because it suits you, because you can say there hasn't been a determination, but she has certainly considered the merits. Speaking for
face
myself, I think I would say that she's actually made a provisional determination.
Well, she doesn't suggest that she
If
has.
you've never challenged, you simply had never made an application, then the stay would have been lifted and the order would have been complete.
No, we say that the stay, well, sorry.
No, if you'd never made a challenge to the order that she made, then under paragraph, whichever paragraph it is, paragraph 6, the stay that on enforcement would have been lifted and the order would have been enforced.
But then we would say that that would be that would be wrong, because a stay should have
Why
been
would it be
substance-
wrong?
Because that would be allowing the stay to be lifted, to make a finding on the substantive claim without a determination of her jurisdiction.
That, with respect, demonstrates why your insistence on there being some further determination is wholly artificial.
Yeah.
I mean, what's absolutely plain, Mr. Hussain, is that the judge, looking at the material that she had before her, thought this was a very strong case for saying there was no state immunity. That's why she made the order she did.
That's not what she says in her judgment, my lord. What she says is that there are some cases where there plainly isn't an exception. So, for example, she can't find the arbitration agreement.
What
It's
she's
talking
saying
about
in
something else.
paragraph 4 is very clear. That's what my lord just put to you. She thought the case against state immunity was sufficiently strong to make an ex parte order. And the effect of it would have been, if you hadn't made any attempt to challenge, that it would have stood.
Could I, sorry,
Yeah.
you may want to answer my lord before I ask the next
my lord,
question.
I think if we look at paragraph 29, she's very clear that she found a prima facie case. And your lordship's suggestion that prima facie, which means on its face, could somehow mean satisfied on the balance of probabilities, I say is wrong. And just on the factual background, she never inquired into it. She got a quite bare paper application without the underlying evidence or legal submissions. The
She would have
evidence
had
is-
the award, I imagine, wouldn't she?
Yes, but not the evidence
No, of
that
course.
was the subject of the award. And of course, your lordships will be aware that my client is not limited to what was said in the award. And the submissions, and the witness statement itself says, of course, that there will be further submissions in due course. So, I will make the submission as strongly as I can pitch it, but there is simply no determination to the civil standard here. And if there were, we would expect it to be contained in some record so that we could look at it. It would
Yeah.
have to be issued to us.
That really brings me to the question I was going to ask. As my lord put to you, suppose you hadn't made any application and there'd been an application to lift the stay, and the judge had simply said, well, I will lift the stay because I haven't had anything further from Nigeria within the timetable that I set. That would be wrong.
Yes.
So what are you saying the judge would then have to say? I think it comes out to a point I put you in this very slightly different context. You would say it would have been all right if the judge, in response to the application for a stay, said, in the absence of any further material from Nigeria, I am now going to look at that material which I do have,
Yes.
and consider whether I am satisfied to the civil standard that there is no immunity.
And I am so satisfied.
And I am so satisfied. And I don't need to give reasons because all I need to say is I'm satisfied by the material put forward by, and the arguments put forward by Mr. Kovacs, since nobody's attempted to answer them. And that's just an empty formality, isn't it? But you say it's an essential formality.
Well, I don't think the judge should engage in an empty formality. She should only say that if she is forensically satisfied.
But she would be, wouldn't she? Well, how could she not be?
Well,
But
she would
she's
need to
only
turn
had
her
one
mind
side of the story.
No, she would need to turn her mind to the materials for the
Well, she's done that. She's made it clear she's done that.
No, she said she's
You
looked at the
wouldn't make the
potential.
order unless you turned your mind to the materials.
She would need to turn her mind to the materials with the same attention that she would had there been an appearance by the state. That must be, at the very least, the effect of section 1.2. She would need to look
She's
at...
got to spend and suggest that the judge didn't turn her mind to the material when she made the ex parte order.
No, she's looked at it from whether it met the test of a prima facie.
Well, no, it's a bit more than that because that's what she says in paragraph 4.
No,
She says there are situations in which you don't make an ex parte order.
yes, because there is
She
something...
clearly thought this wasn't one of them.
But it's in this situation, just to say that I put to you that although, of course, I've been a judge for a long time, I know the distinction between a prima facie case and a case approved to the civil standard.
Yes.
In reality, in a case where only one side has been put, it will be very easy to be satisfied by the prima facie case to the civil standard. They're not the same exercise, I appreciate that. But in reality, where you've only had one side of the story, you are likely to be satisfied.
Hypothetically possible, but that's not something that actually happened here, nor does she say it happened. It's just, if you cannot read paragraph 29 in any other way than her making a prima facie finding, she uses that word. And I don't agree with your lordship that it would be empty, because there would be obviously a careful look at the materials, whether that happened before or happened twice. But I mean, just if we look at that fork in the road provision, for example, having looked at it, it's not in, you don't have the papers before you. But that does, I mean, just looking at the tribunal's reasoning, it requires you to take a view whether that reasoning is correct or not. I mean, there's nowhere that she talks about the arguments individually or not. Individually or cumulatively, on their own merits.
And just suppose it was prima facie case and not to the civil standard. Why is that contrary to the Act in circumstances where a procedure has been made available to you? I don't see anything in section 1 which talks about this sort of procedural question at all. All you can refer to is things said in some of the authorities, which certainly do refer to a civil standard, but in the context of a contested issue.
Well, the authorities,
they would be obviously applicable in this case.
The authorities in my submission do not confine the principle to a contested issue.
Well,
most of them, their facts relate to contested issue.
That's the important thing about authorities. You should always read what any general proposition is in the context of the issue that's before the court.
But the proposition is very carefully put, and I've taken you to a number of times, which talks about whenever a question arises.
Yes, but the question won't have arisen in this situation.
Well, it plainly has, because the very part of the witness statement is that they are asserting an exception to state immunity. And then if we look at...
No, well, it depends what you mean by a question has arisen. They say this point may be run, but if it isn't run within the procedural timetable set by the court, that seems to me to be a different situation from the kind of situation which was being addressed in the authorities.
I'm just trying to focus on the question your lordship is putting to me. I think the point is, we go back to the creature of state immunity. It is not a creation of a plea. That is plain.
Not creation of
a plea, of a claim, of an assertion. It either exists or it doesn't exist. So the suggestion underlying this process, no matter how, and I'm not being unsympathetic to the judges having to work with limited resources.
I'm not suggesting you are. I'm just trying to think of the right analysis.
But the analysis must, in my submission, start from the principle of state immunity and respecting it, rather than how judges will work around in procedure. That is simply not part of the equation.
Well, clearly you're right that it's not a creature of the plea. Courts have to consider it whether there's an appearance or not. That the statute does say. But the way in which the court approaches the determination of it must be affected by the nature of the arguments, by what arguments are raised. I'm just testing the suggestion there has to be a finding to the civil standard. in circumstances where there hasn't been a plea of state immunity, although an opportunity has been given, that's not a complete answer, you're quite right, but it may mean that all the judge can properly be expected to do is decide the case on the prima facie basis, because that's all the material he or she has been given.
And that's
No.
effectively what the judge is saying in paragraph 29, isn't
No,
it?
deciding something on a prima facie basis or on the balance of probabilities is not a function of the material you have. You work with the material that you have. And the judge is very clear that she has not interrogated the material in front of her, or that the material allows her, because she could have asked for more from the claimant.
But it does seem to me to be odd to suggest that she should be required to make a decision on anything other than what she has got. Now, it's clearly unfair to you if you aren't given an opportunity to put more material in front of her, but you were and you didn't take it.
I don't understand that proposition. She had before the claimant, yes? If the claimant had given her materials that she required further materials, and we say she would require them because she would need to.
Why would that's begging the question?
Because it's difficult for me to hypothesize because she has not entered into the task of carrying out the determination, and there is no document where she
Well, you see, I'm putting
tries
to you
to
that
do
she has, as a result of what we see in para 4 and para 29. She made a determination.
I think she
At
made
the
a
time
face-
she made her order. It was a provisional determination because she knew that you might want to put further arguments in front of her. Anyway, I want to resist the temptation of getting into an argument with you. I'm just exposing my thinking,
Yes.
so that you have an opportunity to show why it's wrong. I think I understand what your submissions are, but
Well, I think the whole point is there cannot be a differentiation on the standard of proof based on whether a party appears or not. And if the court made a judgment as a matter of sanction, as we say she did in this case, or without satisfying itself to the civil balance of probabilities, then
Well, your case comes down to saying, I think I've got this, that even in the example my lord and I have been putting to you, where you had simply done nothing, you're not bothered to turn up at all, that before the judge could, as it were, lift the stay and allow the orders to be fully enforced, she should then have made a determination on the balance of probabilities that state immunity didn't apply. And that's your case.
yes, that is my case. The done nothing, if you look at paragraph 12, she was already aware of counter-arguments.
But she couldn't have done that on any other material than the material she had already, because this is on the hypothesis that you haven't put anything else before her at all.
No, but there would be material from the arbitration that wasn't examined.
So she has to go through, what does she have to go through in addition to the material that she has with Dr. Kovacs's witness statement?
I think we're going about it we're having the wrong starting point. The claimant is asserting an exception under the Act. The claimant bears the burden of proof to establish that exception. It bears that burden to the civil standard, regardless of whether the state compares or not.
You're asserting that, but we don't see that in the Act. You referred to it in the case law.
Yes.
That is the case law to which you should
Yes.
listen. It's not the only possible case law, but we've got to consider the extent to which that applies in these particular circumstances.
Well, yes, I don't think it would be right to say that the claimant's burden of proof arises or varies according to whether or not the
They're not burden, standard.
standard and burden, sorry.
Well,
Standard of
nobody's
proof.
disputing they still have the burden.
Okay, that's helpful. So that I do not think it would be right to
Of course,
suggest
anyway.
that the claimant's standard of proof varies according to whether or not the state makes a plea or makes an appearance. Because the fact is that the immunity is not a creature of the plea. And by allowing the standard to vary in this manner, you would be making it a child of the plea. Just to be clear, that we said to the judge that what should be done is directions should be given for her to make a determination. And instead, the sanctions regime was adopted and a determination, no directions for a determination were given.
Yeah, because she said you hadn't complied with the rules.
Yes, and that therefore she did not
You,
meet.
you sought to argue that any default on your part wasn't substantial, or whatever the expression is under Denton. And you also sought to argue that Denton didn't apply. You were just free to do what on earth you liked.
No, we didn't suggest that we were free to do whatever we liked. Obviously, as I've said at the start.
Well, if Denton doesn't apply, then you must be free to do whatever you like, mustn't you?
No, because the court can still set its own procedure. What we say can't be right is that as a matter of sanction,
But
the stay on enforcement can be lifted
Wouldn't the
without
whole-
a determination.
sorry, I didn't interrupt
I'm
you,
sorry.
but wouldn't exactly the same problem have arisen if the judge had acceded to your request to make directions, say, all right, whether as a matter of discretion or because I can't, I'm not going to apply any sanction. I now need to set directions, and you must put evidence in 42 days, a hearing on such and such, and you don't comply with that. Wouldn't your argument be precisely the same? That she can't, she's still got to go ahead and make a determination despite your non-compliance.
No, my argument would not be, I wouldn't have an argument.
What would be the difference between the two
Because
situations?
this is something I've been trying to emphasise
Okay.
through the written submissions. I'm sorry it's not coming across. What we're saying is we are not suggesting that the court cannot sanction a failure to follow the procedure for the determination. So the sanction would be your statement is late, or the example of discovery that was given in J.H. Rayner. But the sanction cannot be I thereby find that an exception to immunity arises.
Yeah, but I don't see any sign that's what the judge did.
But what she did was she said, I do not need to proceed to make a determination.
Yes, but that's for a different reason. That's because she's already made one.
No, that's not what she said, that she's already made.
Well,
And there isn't one on the papers. That is an essential point of difference, or essential proposition. And in my
so
submission,
what would the purpose, what would the point of this? What you're saying is that if there was a non-compliance with directions that she had given, she could impose a sanction. The sanction could be anything you liked, except not continuing to decide to make the determination.
you cannot substitute a sanction.
What do you mean by substituting a
The
sanction?
determination can't be a deemed determination by way of sanction.
Yes,
It
okay.
cannot.
No,
you can't
if that's
say-
what you're saying, I
Yes.
understand it.
And if this had been a Mauritius type situation where she'd made a determination on the civil standard and we showed up after that, yes, she would be entitled to say, subject to any relief from sanction that we sought. Okay, well, I've already made my determination.
All right, I think we got the point then.
Just the last point, just on this determination, is it's worth noting that till this 52.30 application was not suggested that a determination to the civil standard had been made. I'm still not sure it's being suggested, but if we look at the application bundle,
Mm-hmm.
yeah,
What are we looking at?
spare me a second. It's the
What
tab.
is Mail's determination?
It's tab. So it's just a point, Madam, that it wasn't suggested, or I don't understand it to be suggested that a determination has been made to the civil standard. If we look at tab 8 in the appeal bundle, and we see a page, sorry, not the appeal bundle, the application bundle, I'm so sorry.
Yeah, sorry. Yeah.
You should have exhibit TB3, is that the document you have?
Yeah, what are we looking at there?
And we turn to page 43, we see the respondent statement under CPR PD 52C. And then if we go to page 45, footnote 9, It also bears recalling that the court came to the prima facie view that state immunity did not apply. Hence, it made the enforcement order. There's no suggestion from the respondent that there was a finding on the civil standard, and the same is said by the appellate judge. If we go to
Well, yes, I mean, this is the point my lord was putting. And the critical question here is whether in the circumstances, in these particular unusual circumstances, the court was required to do more than reach the determination. I know you don't like the word determination in the context of what Mrs. Justice Cockrell did, but the determination that it was a prima facie case for enforcement. Therefore, a prima facie case that there was no state immunity, but had to go further. I mean, that's your whole case is that the court had to go further.
yes, and that's on the basis that there is no basis for a distinction, either under international law or the Act, to say that a different standard of proof applies. And if we just while we're here, if we look at Lord Justice Miles's...
Can we just finally bottom out? I may have been too hasty in saying that I appreciated the difference between a prima facie case and a case proved to the civil standard. I mean, a prima facie case means a case which satisfies the court unless evidence or argument to the contrary is advanced. What exactly is the distinction between that and a decision to the civil standard?
Well, firstly, the distinction I was acknowledging was between an arguable case and a decision to the civil standard. But she does say prima facie case, which is different from arguable case. well, the reason we're having to speculate is, in my submission, precisely because there wasn't a determination. There is no document which contains a determination.
Well, I dare say, but we're looking at what she says she did.
Yes, and if we look
you
at what
yourself are relying on.
yes,
What is it? What's the answer to my lord's question?
it's plain that she hasn't made a finding on the civil standard. She has not interrogated or given any reasons for such a finding.
Well, reasons is a different matter.
What's the difference between a prima facie case which satisfies the court unless evidence to the contrary is advanced, and a case decided on the balance of probabilities where evidence to the contrary is advanced? I mean, it's just two sides of the same coin, isn't it?
I think that's proposition. She didn't suggest she made a prima facie finding which satisfied her subject to any other evidence. Prima facie would mean, in my understanding, that she's found an arbitration agreement which could arguably cover the dispute.
Right, is that right? If you, she used the phrase prima facie in para 29, there's also be wrote para 24, which makes it clear that she regards a distinction between cases which do raise a prima facie case, where you make an order of the kind she made, and cases which don't, where you don't make an order, and require a hearing.
Before you make the ex parte order, yes.
Yeah.
But that distinction is simply to whether or not, even on its face, there is a arguable case.
Prima facie, you might say. Well, when you say arguable case, prima facie case, that's the phrase she uses.
Well, I would suggest that there would be an artifice in a proposition, and I know you're just raising it to me for the sake of argument. But even for the sake of argument, there would be an artifice in a proposition that the judge gets on a very fact-heavy dispute a paper application for a ex parte order, which she makes in the terms proposed, and says that she saw a prima facie argument to suggest that that was a finding, that she somehow conducted a finding to the civil standard of proof, when there is no statement by her to that effect or any document.
What I'm still struggling with is this. You said a moment ago that you weren't suggesting the court can't impose sanctions. So leave to one side your complaint that the judge ought not to have imposed sanctions here, which seems to me at least to be extremely difficult to argue as a ground of appeal, because it's entirely a matter for the judge in her exercise of her case management powers. But leave that to one side. Assume the judge was entitled to impose the sanction she did. and to say you're too late to raise anything. You maintain that the judge still had to make a determination on the balance of probabilities. What I'd like to know is, what do you say exactly what the judge should have done? Should she have said, I'm now making a determination on the balance and probabilities, and I decide that Section 9 applies as an exception to state immunity? What do you say she should in fact have done that she didn't do?
So just so I understand the postulation, you're saying if there was no basis to object to her sanctioning any further evidence from Nigeria on account of the delay between the appearance, time allowed for an appearance and the actual appearance, what should she have done? What I say is that she should have made a determination to the civil standard. I think you're asking, my lord, what that would look like in my speculation. That would be entirely a matter for her. Obviously it would be subject to appeal, but it would need to be an intentional and careful examination of the evidence before her and a finding of whether or not she found on the balance of probabilities that an exception to state immunity exists, and that would require her to go through, at the very least, the evidence that was before the tribunal.
What evidence was before the tribunal?
So there was witness evidence.
She's got the material that has been put before her by the claimants, and on this hypothesis, that's all she's got, because you failed to comply with the rules.
The claimant will
the
have...
predicate here is that your argument that Denton and Hall, for whatever reason, shouldn't apply is wrong, and therefore you are, as it were, out of the picture.
So the claimant who has a burden of proof will have access to the arbitration documents, the evidence. It will obviously have representation, so we'll be able to, for example, satisfy her as to the legal issues. There was a very live legal issue as to the fork in the road provision, for example, and the meaning of the investment. That's just not an exercise that she embarked on. Now,
what if the judge has said, well, I don't actually need any more than what I've already got? It's perfectly obvious on the material I've got that this is a case where Section 9 applies.
If she did that, then obviously that decision would be amenable to appeal if she had missed out on something important or taken a view that wasn't justified on the papers before her. But, I mean, the determination is important, I say, for the jurisdictional issue, i.e. to establish that the court has jurisdiction against the state. It's also procedurally important. It cannot just be implied by the issue of the ex parte order, because then there is no way to review that judgment, no way to appeal that judgment.
Now, Mr. Hussain, we have rather taxed you.
My lord, just one more.
It is 20 to 1, and I'd like to give Mr. Harris at least an opportunity to say something if he wants to.
Of course, my lord, and I'm really sorry to press you. The last document that was on is Mr. Melles's, so Lord Justice Melles's reasons.
Yeah.
And if we go to the herring bundle at page 3, item 3, he says in terms that she concluded that there was a prima facie case that there was no immunity.
Yeah, got
and then item 4, he says, if a claim to immunity had been made, the court would have been required to determine it. It's quite plain that neither the respondent nor...
But he goes on to say, as no such claim was made, because you'd failed to comply with the rules, the court is entitled to proceed on the basis there is no applicable immunity in this case.
And that we say is plainly wrong. Proceed on the basis, not proceed on a finding made to the civil standard. It's literally, it is, and this is what has happened, is that the court is entitled to assume, without a determination, that an exception to immunity arises. Well, before I sit down, I do want to apologise for my tone earlier.
Don't these things happen?
I apologise.
Yes, Mr. Harris. Do we need to hear? Sorry,
That's fine, yeah.
Just on is there anything else you want to say about Denton and White, or what is it?
Yes, I mean,
writing?
I'm not sure time allows, but you mean on the PTA or on the 52.30?
Well, just on the PTA point, because I think you've said that the court, you weren't suggesting the court couldn't impose sanctions, and normally, unless this court thinks that the judge below has misapplied the principles, we leave these sorts of
Yes,
decisions
I'm sorry, I prompted
well
my lawyer,
alone.
but
Yes.
there's formally, you have two strings to your bow. One is effectively your ground one, which is that there was never a determination, end of story. Your fallback position is, even if the judge was allowed to take a Denton point, she got it wrong, and you make various particular points in your Stelliston,
Yeah, so there's
which are, I don't wish to express a concluded view if you want to address us about it, but if those were your best points, you might have, I suspect you recognise you have a bit of an uphill struggle.
yes.
But I just want to know whether you want to add anything to what you say in your Stelliston about those.
I just want to highlight that ground two goes to whether or not a sanction by way of enforcement, that whether the stay can be lifted, absent a determination.
But that goes with
Yes.
round one.
Yes.
But I mean,
So-
I'm forgetting which round was which. But there are some sort of conventional points that she misdirected herself. She thought there
Yes,
was about the length of a trial, and
Yes,
which seems pretty an uphill struggle for you.
Well, I think there are two solid points there. I'm not saying the rest aren't, but the ones I would emphasise to you is firstly, one of the points for overturning a Denton exercise of a discretion under Denton is whether or not an irrelevant factor or a factor that shouldn't have been taken into account was taken into account. And we say that there were two factors here that were wrongly taken into account. One was that somehow there was an abusive process. We say that raising immunity or having to determine immunity would amount to an abusive process. And we say
Hang on a moment, say that again.
sorry, it's difficult to do it in a rush way, but you'll find if I can.
Sorry, I couldn't hear you properly
Yes.
because
One of the-
occasionally the acoustic in this course is very bad.
One of the points the judge raises is that she did not feel that in weighing the factors, she saw it as relevant that any state immunity defence or any assertion of state immunity could be, she didn't decide on that, could be an abusive process. And we say that that is simply wrong as a matter of law. The immunity is a question for the judge to decide. It cannot be an abusive process, but on the facts, there is nothing abusive about, on the one hand, bringing a Section 67 application and then raising immunity in another proceedings.
Okay.
And we say the same thing about the waiver argument. So just bear with me 1 second.
Sorry, I stopped.
No, I think that's
My learned junior just are keen for me to make the point that prima facie in our submission means at first sight.
means what?
At first sight, or on its face.
It means as a matter of Latin.
Well, he speaks more Latin than me,
Latin,
so
Latin,
yes.
it means that, yeah. Okay, all right, we've got a point. Thank you.
My lords, I recognise that it's 15 minutes to lunch and I don't want to labour any points, so my lords will no doubt feel free to interrupt me and direct me to the points on which they would require assistance. My lords, you will have firmly in mind the fact that what we're engaged with here at base is the enforcement of an arbitral award, which is done by way of an ex parte application. You can see in the guidance in the White Book to CPR 62.18, and that's on page 937.
There's no point referring us to the White Book because we've been deprived of White Books in court.
Well,
So unless you've got another copy of the White Book.
I'm sure it's a pretty standard
it
proposition.
simply says
It's a pretty standard proposition. It's in part 62.
in
Is it?
62.18, the commentary on 62.18, it says
62,
18,
18.
point 18, which is the relevant provision, says the procedure under this rule is intended to be a summary one However, the court has a discretion as to whether to make an order under it or not, and where disputed issues of fact arise, it can give appropriate directions under 62(7). Not controversial, not surprising. I just wanted to reinforce that point. That's precisely tracks what Mrs. Justice Cockrell said, what the commercial court does. If the judge, considering the application on the papers, considers that there is doubt as to whether an exception to immunity is made out, they don't make the ex parte order, they direct an inter partes hearing. At that hearing, the thing is argued out.
Yeah.
But only if they consider, and that's why I think this prima facie discussion that my lords have been having with my learned friend, it is, in one sense, a red herring, because the very fact is, as Mrs. Justice Cockrell described in her judgment, unless the court is satisfied that an exception to immunity is there, it doesn't make the order. The court's under no compulsion to make the order. It then directs a set aside. Now, it's right to say this judgment was an ex tempore judgment which was transcribed. And in paragraph 29, for example, the judge says, there's a slip where the judge says, if there's an issue, the court will require service of an application before an ex parte order is made. Obviously, that's not what was meant. It requires service of the application before any order is made. That's just to make clear in paragraph 29, line 6, when the reference to ex parte order, that's what the judge is meaning there is, no, you won't make an ex parte order and you direct service of the application, and then you have an inter partes hearing, which is what Mr. Justice Tier said in Gold Reserve in Venezuela, which was referred to by the judges, also in the bundles, I think, before the court.
Yeah.
So there has been a determination. My learned friend showed you our application in the bundle. It's tab 9 of the what in my version is called the core bundle.
Yeah.
He showed you, looked at it, it was laid out that Nigeria may raise immunity. That isn't the same as Nigeria actually asserting its immunity. It is a point that is being made that it may. And that then the court considers, well, if it did, what would the answer be? And Dr. Kovacs set out with some detail and reference to the final award, which is in tab 16 of this bundle, in case that's of assistance, my lords.
Yeah, we've seen it.
Where Lord Newberger and his fellow arbitrators set out over several pages why these arguments were bad. And the suggestion that the judge didn't look at that is pure speculation by my learned friend, and in my submission, inconsistent with the judge's judgment that she gave on the later hearing.
Well, that's why she refers in paragraph 4 to the merits,
Yes.
meaning there were no merits in her view.
Lord, yes.
She wouldn't have made the
And whilst it's a different point, picking up on the same point, when my lady, Mrs. Justice Cockrell, was considering the Denton argument, as she makes clear, obviously the merits of an application for immunity at that stage would be relevant. But as she makes clear in paragraph 43 of her judgment, Nigeria had come to court empty-handed. Nigeria was applying, and this is quite important, Nigeria was applying out of time for a retrospective extension of time. It didn't come with an immunity application saying we are asserting immunity. It came with nothing, and indeed, my lords, and this was the other point, in addition to the abuse ground, we had said, and it's perhaps relevant for me just to show you that, the application that was made to the court by Nigeria on the 15th of September, that if we just turn that up, that is
tab 10.
in tab 10, that application, so it is an application which says not a word about immunity. And what it asks for, you can see on 136, the draft order, it asks for paragraph 4, I know I'm referring to paragraph 5, paragraph 5 is a different point. Paragraph 4 of the enforcement order is for the defendant to make an application to apply or set aside a variety that should be extended by 28 days.
Sorry, where are you reading from?
This is paragraph 1 of page 136, the draft order that, that Nigeria sought in its application. Now, of course, my lords, as you can see from Mrs. Justice Cockerell's judgment, the evidence before her was that at the latest, Nigeria's time had expired on the 16th of August. So a 28-day extension wouldn't even get you to the 15th of September. So they were applying for an extension to bring an application, which extension, had it been granted, would have already expired.
So
at the time that the application was issued.
what's the time limit? I'm not saying you're wrong. 15th of August to
16th of August was the latest date on which their time to apply
yes, I see.
under paragraph 4 would have expired.
And but this is so. What the date of the hearing is?
The date of the hearing is the 2nd of December, but this is an application made on the 15th of September, which is seeking a 28-day extension to their time. So 28 days after the 16th of August, which had already run out by the time the application was made. And just so that there's no confusion in the court, because we've noticed when preparing for the hearing, over the page at 137 and 138, you have defendants' proposed directions, which do mention immunity. It's very important that the court is clear that that is a bundling issue.
So which
if you look at pages 137 and 138, on page 137, paragraph 2, it says that the defendant has permission to apply to set aside on the grounds that it's immune. This document formed no part of the application of the 15th of September 2022.
Well, in what sense?
It wasn't filed with it. This document, my lords, was filed. You can see in two ways. One, you can see by the referencing at the bottom of the page, which is different. But two, you can actually see because it was exhibited to Mr. Balogan's second witness statement of the 28th of November, at tab 12 of the bundle, where he even introduces it. He refers to it as paragraph 49 on page 169 of the bundle.
So what page of the bundle?
169, my lords.
This is the point that they didn't actually raise until just before the hearing, before Mrs. Justice Cockerell, the issue of state immunity at all.
Correct. They applied to the court for an extension of time without saying it was for immunity. And that's a further point Mrs. Justice Cockerell deals with in her judgment, that we say, irrespective of anything else, would be a waiver. It's on all fours with the Prestige case, because they would have applied to the court for an exercise of the court's jurisdiction, not for the basis of immunity. So paragraph 49 here on page 169 of the bundle, Mr. Balogan on the 28th of November says, Ms. Polikarpou also queries that if time were extended, what directions Nigeria seeks. And although I understand it's a matter for submission, and case management will be set for another day, I attach to this witness statement a proposed draft order to assist Zhongsan in understanding Nigeria's position. And that was where this defendant's proposed directions at 137, 138 came out. I would hope that isn't controversial. But you can see...
I haven't checked, but I mean, it's implicit in what you're saying. There's nothing in Mr. Balogan's first witness statement about
there is nothing at all.
About immunity.
No.
The only thing he says about immunity is about the time for service under section 12 of the State Immunity
Where
Act,
does
which
he
is a
say
completely
that?
separate point.
Where does he say that?
That's at paragraph 12 of his first witness statement, page 141.
Yes, well, that's not about, it's about the Immunity Act,
It's about service,
but it's about service, yes.
and the deemed date of service. And my lord, the point I was making earlier is if you look in the bottom right of the witness statement of Mr. Maloney, you'll see an internal sort of law firm coding on the document, 014-6011.
Yeah.
If you look at the previous page, it's 1460523, totally different. But that coding is identical to the coding on Mr. Balogan's second witness statement. I'm making these points, but it ought not to be disputed. We've gone back and checked. This simply was not filed at the time. So, my lord, what you have here is a situation where perfectly standard procedure followed. My clients apply to the court, put forward the award, says Nigeria might raise immunity. If it does, it's a bad point. The judge forms the view that we are right about that, therefore makes the order, but in the usual way, because Nigeria wasn't present, gives them time to apply. That we even went so far as to be very generous and give them in paragraph 5 an extra period if they applied on the basis of immunity to raise any other ground after that immunity was determined, so they wouldn't be put on the horns of a dilemma as to whether to put in other objections to the award.
So what you say in summary is that given the nature of the summary procedure for enforcement, which is reflected in both in the Act and in the rules, this was the making of the ex parte order was a sufficient determination if such determination is needed, without more.
Absolutely.
So when we get to the point, put the example that we put to Mr. Hussain, where either, as the judge found, they'd failed to comply with the rules, therefore they weren't entitled to raise the point, or the example where Nigeria don't actually do anything at all, you would say there was no requirement for the judge to make some further, as it were, further and better determination, or to trawl through the material you'd given her, saying, well, this looks like a good point, this looks like a good point, this looks like a bad point, etc., and then make some judgment which was capable of being appealed on a separate basis.
Correct, Lord.
Because they'd either not complied with the rules or they'd not bothered in that example.
We would say, my lord, that it's regrettable that it's suggested that Mrs. Justice Cockerell hadn't gone through the materials.
Well, she clearly had.
It's clear that she had, as any commercial court judge would. Commercial court judges, in my experience, certainly are not in the habit of making orders against states.
Well, especially if it's this sort of case against the state, because you always look. The first thing you look for is what the argument is for saying that there isn't a state immunity answer.
Well, and it's been raised squarely and in detail in the witness statement.
Yeah,
it's
quite.
there. So we say that she had determined it. That determination, this prima facie point, goes nowhere because, for the reasons that my lords put to my learned friend, it's prima facie only in the sense of being provisional because it's based only on what we've put before her. Mm-hmm. It is not. The judge isn't saying that I'm not satisfied that this is right, but if I have a very quick look at it, it passes the smell test. It's not that sort of case. When my learned friend referred you to the J.H. Rayner case, the Tin Council case, and the reference there to a good arguable case not being sufficient, that was a totally different point. The point that was being argued there was when you decide immunity. And it was being submitted to the court that where you can show a good arguable case against immunity, you wrap it up. You park it and wrap it up to be dealt with the substance at the end.
Well, that was the argument about the sort of argument about jurisdiction under CPR Part 11. Well, good arguable case, or you know, much the better of the argument, or whatever the precise formulation is.
Yeah.
That's an interlocutory determination
But
to a particular standard, and that's effectively what is being referred to there, isn't it?
so what was being said is, what you shouldn't do, in that case, in Tin Council, what was being said was you shouldn't have a separate hearing now on immunity and pause the merits proceedings while you do that.
Yeah.
What you should do is decide whether we've got a good arguable case. If we have, that there's no immunity, you park immunity and we determine it at the final merits hearing.
Yeah.
What the Court of Appeal, what Lord Justice Carr and Lord Justice Rafe Gibson said is no. If immunity is raised by the state, if there is an application asserting immunity, you determine it now, because otherwise you've got no basis to exercise your jurisdiction. Good arguable case isn't enough. But we're not in that position.
No.
This was dealt with right at the start by the judge before she did anything else. It was determined.
Yeah.
And Nigeria never actually, even today, this is one of the mysteries of this case that we made in our skeleton, we made the point. Even today, the submissions are made as if the court is case managing an immunity application. There is still no immunity application.
Mm-hmm.
Nigeria hasn't applied. It hasn't applied to say that the judge's determinations were wrong on the immunity points. It says she treated their case wrongly in that she didn't give directions, because what they wanted was another 3 months to file an application, which would have led them 7 months out of time. That's what they were asking for.
Yeah.
So that's how we say it works.
Right. Okay.
And I think I dealt with the Denton point on passant. I mean,
I think we probably heard enough, Mr. Evans.
I'm grateful.
My Lord, can
Do
I
you want to reply?
just very briefly, because I'm grateful for the time you've given me already, can I just bring us back to what today has been a permission to appeal application. So your Lordships have to decide whether the arguments have any real prospects of success. And we are in a situation where the authorities are quite clear that without an exception to immunity, there is no jurisdiction. That is different from a Section 11 case where the court withholds its jurisdiction in case of an arbitration agreement. And I say that whatever your views on the merits of the case, there is enough there on the grounds to have real prospects of success. We do not have, the answer to the grounds is that somehow there was a determination made to the civil standard without any statement when it was made, where it was made, and on what basis. And there must be at least a real prospect of success of showing that there wasn't such a determination, and a real prospect of success of showing that absent such a determination, this stay should not have been lifted on enforcement. Lordships will also bear in mind that this is a matter that has considerable importance outside this case in terms of the approach to state immunity where the state does not make an appearance. And it is worthy, in my submission, of a full appeal.
Yeah.
Thank you.
My Lord, will you forgive me? There's one point very briefly that I should have mentioned. That it's been repeatedly said that there had to be, we had to apply to the judge to lift the stay. I don't want there to be any misunderstanding. It's automatic. The stay is automatically lifted if no application is made.
I know it's been referred to as an application. It's an automatic. If they'd done nothing, the stay would just go.
Lord, in fact, it did go and had gone before they applied for an extension of time.
I know. Okay. Should we just rise?
Yeah, let's just rise.
We're just going to rise to discuss the matter, so don't go away.
Court rise.
in the circumstances that we reserve our judgment, and you'll get it in draft in the usual way, hopefully before the end of term. I'm not going to make any promises, either on my own behalf or on behalf of my lord. As you know, that's for the purposes of correcting any typographical and similar errors, not for inviting further and better argument. Please pay attention to the terms of the embargo at the beginning of the judgment, how important that is. And if in due course an order can be agreed between you, that would be very helpful. But for the moment, thank you both very much for your very helpful submissions, and to your juniors and solicitors as well. Thank you.
Court rise.